Good morning to everybody.
Morning, Chair.
How are you, Honorable Swart?
Very well, thanks, Chairperson. Yourself?
No, I'm okay. Thank you very much.
Good morning.
Morning, Honorable Self. How are you?
Morning.
Morning.
Fine,
Morning.
thanks.
Thank you very much.
Good morning, Chairperson.
Morning. How are you, Mr. Mangana?
I'm fine, thanks, and yourself, Chairperson.
Thank you very much.
Good.
Good morning to everybody who's watching from home.
Chairperson, my
Honorable
apologies.
Home.
Yeah,
Yes.
will you please note the apology of the Honorable Breitenbach? She might join late, but she unfortunately had to run to a dentist this morning.
Okay.
Thank you.
Apology noted. I've also received an apology of the new member, Ms. Komoto, who is not well. She will join us as soon as she gets well. She's from the ANC.
Thank you, Chair. Can you
Honorable Janji?
Can you also just note the apology of Honorable Ngola, who has a doctor's appointment? He'll join us late.
Thank you very much, Honorable Janji. Honorable members, we have 3 agenda items for today. One, it will be the presentation by the Department of Health on the Cannabis bill, and then followed by the Criminal Procedure Amendment Act, public hearings, a presentation by Child Justice Center, and then after that we will deal with the minutes. Is there anyone who is representing the Department of Health?
Recording in progress.
Hello?
Chair.
Honorable Swart?
Chair.
Yes.
Chair, can I just get an idea on, I briefly alluded to the issue of the public hearings on the cannabis issue and the fact that there are 2 days set aside for the departments, but only 1 day for public hearings next week, only being in the morning. Can we, as a committee at some stage, just discuss that? Because I would think we need more time for public hearings, given that we are giving 2 mornings for inputs from the departments, and these are very far-reaching issues. Maybe I don't know if you've given any thought to that yet, but thank you, Chair.
Yes, thank you very much, Honorable Swart. We have the committee secretary will respond to that. Mr. Mtunjani?
Morning, members. Morning, Chair. Yes, Mr. Swart, we have taken the proposal into consideration, and we have altered the program. It's just that we were still applying to sit for Thursday and Friday. We will send the updated program once we have received the approval to sit this week with the updated dates. We have the criminal procedure hearings today. We've then made space for the 30th and the 1st of September. We've given the hearings on the cannabis bill 2 days on the program, but we'll send the updated program after we've received approval to sit the rest of this week to members. We did cater for the 2 days. We did extend for 2 days, Mr. Swart. Thank you.
Thank you very much, Mr. Mtunjani. I hope you answered, Honorable Swart.
Yes, thank you, Chair. I would also just like to, at some stage, also get an understanding of which organizations have been invited and how many submissions we received, but that we can also do at a later stage. Thank you, Chair.
Yes, can we do that? Maybe can we deal with the program immediately after we have dispensed with the program of the day, so that we are taken through the whole program? Is that fine, members?
That's in order. Thank you, Chair.
Thank you very much. Thank you very much. Let me just make this brief remarks with regard to the issue of the departments that will be appearing before us with regard to the cannabis bill. We thought that we need to have the lead departments who are involved in the master plan, in the cannabis master plan, just giving us a flavor of what is contained in that master plan and which programs broadly are they implementing to ensure the implementation of the master plan. Because you remember, members, when we discussed this matter last year, our view was that we don't want a silo approach to this issue. We want to have an understanding of a broader government implementation of the reindustrialization or industrialization of the cannabis to improve our economy. And there will be various pockets of work that is being done by various departments. And we are also a contributor with regard to the cannabis bill, cannabis bill for private use bill. So we have invited the Department of Health, that lead Pillar 1. We have also invited the Department of Agriculture and Rural Development, that is an overall leader, and the Department of Trade, Industry and Competition, that is responsible for the industrialization and commercialization of cannabis. Today we will be dealing with the Department of Health, and then tomorrow it will be Rural Development, Trade and Industry. We will not be able to cover all the departments because of the time pressures. But by the time we start with our public hearings on the 30th and 31st, at least we would have that broader understanding of what is happening broadly in government with respect to this issue of cannabis. Those are the brief remarks as to why we have invited these departments to come before us. Over to you, Department of Health. You have 30 minutes.
Good morning, Honorable Chair, Honorable members, and colleagues. My name is Anbin Pillay. I'm the Deputy Director General at the National Department of Health. I am joined by Advocate Maobelo, who has been intimately involved in the cannabis bill for a while now. I have also invited a colleague from the South African Health Products Regulatory Authority, which is an entity of the National Department, Ms. Fafudi. What we've done in preparing this presentation, Chair, is bring together our Medical Research Council, SAPRA, and ourselves, and looked at the bill and combined our inputs so that you don't have to necessarily go to each of our entities within the health sector to get responses. And so this presentation is intended to be a combined presentation. Chair, we did receive a request yesterday evening that we should also include our inputs as they relate to the master plan. And so we have added that in, and we do apologize that we didn't have an opportunity to share a few of those slides with you, but we will do that today and share them with you. The presentation will be a joint presentation between myself and Advocate Maobelo. I'll provide some introductory remarks, and Advocate Maobelo will go through some of the clauses that we have comments on, and then I will share some medical related issues that we would like to raise. So, Chair, if I go to the actual presentation, hoping that you will be able to see, you are able to see the presentation. Thank you. So Chair, I think if I can just make these brief introductory remarks before Advocate Maobelo moves to the other slides. I think it's important for us to acknowledge that the legal decision to decriminalize the cannabis for private use is a correct one. It's certainly not appropriate from a human rights perspective that people are basically locked up for use of cannabis, and to give them a criminal record and state resources are tied up in those activities. So I think we welcome that. While the bill does acknowledge, I think, the need to protect children, others in the vicinity of cannabis smokers and other road users. We believe that the bill needs to have some amendments to those areas, and Advocate Marbella will talk through that. This may also require some changes or emphasis in legislation and maybe a bit of restructuring around the bill in terms of our own suggestions relating to this. So as I was saying, Chair, this is a combined presentation, and I'll ask Advocate Marbella to take you through the preamble and specific clauses in the bill, and then I'll continue at the end relating to some of the clinical issues. Advocate Marbella.
Thank you very much, Dr. Pillay. Good morning, honorable members and colleagues from the Department of Health. Thank you, Dr. Pillay. I'm going to present on the part that relates more to legal. So in the preamble, it is stated that it aims to protect children against the harms of the cannabis. But the bill, rather than protecting anyone against the harms, will rather regulate access to cannabis for adults for personal use and prevent access and exposure to children. I think access and exposure there, as they are in bold, they are being emphasized. We then suggest the following, that the preamble should then read, provide access to cannabis for personal use to adult and prevent access or exposure of cannabis to children. The main emphasis there being the exposure to children, the interest of children being taken into consideration. Next slide. Dr. Pillay. Okay. We then dealt with the issues of definitions as they are used in the bill. Cannabis is defined as the flowering or fruition tops and the leaves of a cannabis plant that have been separated from the plant, but exclude any seedling, the stalk and branches without any leaf, fruit or flower, and the roots of a cannabis plant. And B, which is underlined here, paragraph B, and then said, any substance which contains THC, means that cannabis is any substance which contains THC. We think that paragraph B broadens the definition of cannabis too wide to include food as a substance, because it says a substance which contains THC. We currently have a proliferation of substances containing THC in the form of food and sweets available in the streets, which is a challenge. We think that children will consume this THC containing food and the consequences may not be child-friendly. This is because we are of the view that cannabis added in food will not have a nutritional value. Next slide. Paragraph B further creates unintended, unreasonable inclusion of the smallest amount of either a naturally occurring or synthetic form of THC as cannabis. THC is already regulated under the Medicines Act and as a Schedule 6 substance. The manner in which the word cannabis is then used in the proposed legislation may create an ability to circumvent the provisions of the Medicines Act, meaning we may not have the line between Medicines Act and Foodstuffs Act then will become very thin when coming to regulating cannabis containing food. We suggest the following in paragraph B. To say cannabis means the flowering or fruition tops and leaves of a cannabis plant that have been separated from the plant, but exclude seeds, seedling, the stalk and branches without any leaf, fruit, flower, and roots of a cannabis plant, and fresh cannabis, dried cannabis, and a cannabis concentrate are classes of cannabis. That is the new suggestion that the members will have to consider. Next one. We further went on to the terms cannabis concentrate, which means cannabis that has undergone a process to concentrate the THC content. That means to increase the THC content. And cannabis solid concentrate and cannabis liquid concentrate are classes of the cannabis concentrate. Cannabis may also be concentrated for the intended purpose of obtaining high concentrated forms of cannabinoids, or not just THC. The definition should instead focus on the resultant product of the concentration process and not the intention of the concentration process. We suggest the following. Cannabis concentrate to mean concentrated cannabis substance containing THC obtained by processing of cannabis or any cannabis derivatives, and cannabis solid concentrate and cannabis liquid concentrate are classes of cannabis concentrate. Next one, doctor. And then we went on to cannabis product. What is the cannabis product? The current in the bill says is anything that is intended for human or animal consumption which contains THC or any other phytocannabinoid found in cannabis plant. This definition, juxtaposed with the definition of consumption, seems to suggest the inclusion of cannabis as food. Thus, the THC containing product may have adverse effect on food. The members of the public may think that cannabis product is food and may be consumed as such. So we are of the view that the bill on commercialization and use of cannabis product should be the one that deals with the element of consumption of cannabis. We therefore are of the view that you may have to consider to delete paragraph B that has got an element of consumption, which consumption, when you define it, it links to food because it says it's anything that you eat or drink. So that's why we're having an issue with that one, because cannabis in food or THC in food it doesn't have a nutritional value. So the word consumption, they seem to suggest that cannabis has a nutritional value and may be regarded as food, or it may be added to food for consumption, which in terms of the foodstuffs and cosmetics and Cosmetic Act, that is not the case. We therefore are of the view that you may have to consider to delete consumption so that so as to avoid the confusion between consuming cannabis product or cannabis itself as food. Next one, doctor. We also looked at the harvest, which means obtain and process cannabis from a cannabis plant. Remove the processing from definition, as processing does not fall under harvesting. So these are two different processes. Harvest should be considered separate from any post-harvest process. You can refer to the good agricultural and collection practices from the World Health Organization. Next one. Hemp. Hemp, as defined, it means a plant of the genus Cannabis, which has a concentration of THC in the leaves and flowering heads that does not exceed the percentage as may be prescribed in terms of, and is cultivated under authority of the law that regulate the cultivation. So hemp, which is a low THC cannabis, is a cultivar variety of cannabis. See also the general comment of the creation of the term hemp, which is expediency of legislative drafting, but may create confusion, meaning the two terms as used, cannabis and hemp, may be very confusing. And then we suggest the following: for hemp to mean a variety of genus Cannabis, then means we leave out the plant. We say it is a variety of the genus Cannabis, which has a concentration that it does the same. The only change there will be to bring in the word, the new word will be variety, and then you omit plant. The next one. Process in private. It is stated that for the purpose of section 2(1)(c) and (e) means to keep, store, transport, or be in control of cannabis or a cannabis plant, respectively, in a manner that conceals it from the public view. We say refer to the comment on definition of cannabis and the implication for cannabis-related medicines and possession thereof. So the essence of specific exclusion for all activities authorized in terms of the Medicines Act and the definition of cannabis result in this legislation creating an offense for the possession of cannabis-related medicines or medical devices authorized for such in terms of the Medicines Act when not concealed from the public. The next one. This is the most important one, smoke, which means inhale or exhale the smoke produced by ignited cannabis or holding or otherwise having control of ignited cannabis or any device or object that contains the ignited cannabis. So this definition ignores the growing heat but not ban market, such as vapes or other electronic nicotine delivery systems, which can also deliver THC. You know, the new generation product in the tobacco industry is that they are constantly coming up with new product. There's a new product that's a heat not burn, meaning there is no smoke, but the user is inhaling a nicotine through the electronic nicotine delivery system. So if the definition of smoke only related to ignited, then it means it's going to exclude such kind of product which may also be used in this that are currently being used in the tobacco industry to be used here. So clarity is required between the definition of a smoke and consumption in order to clarify the consumption of smoking of cannabis in public places as ambiguous with respect to, of this means of administration. The next one, Doc. We are now done with the clauses, comments on clauses, inputs on clauses. We go in, on definitions, the terms that are used in the bill. We have realized that there is clause 1.2 in the same clause 1, which talks about the application of the act. It says the provision of this act do not apply to any person who is permitted or authorized in terms of any other act or any other act of parliament to deal with plant cultivation material, cannabis plants, cannabis or cannabis product, or cultivate cannabis plants. We are of the view that clause 1.2 should be a clause on its own, which will deal with application. It seems that this clause is misplaced in clause 1. It can be created as clause 2 and deal specifically with application, rather than to be in the clause that deals with definitions of the terms used in the bill. We are also of the view that clause 1.2, which provides for the application of the act in the bill, does not contemplate the possession of cannabis plant cultivation material, cannabis plant, cannabis or cannabis product, which in the case of medicines may have been arrived at by way of but not limited to prescription, authorization, and licensing. So this is now the second issue. The first one was separating clause 1.2 from clause 1, and then now we're saying as it is now, it does not deal. The exclusion does not contemplate the position of cannabis in relation to Medicines Act. The subsection should, in order to avoid any unintended consequences, as already stated about, specifically exclude any person and any activity permitted or authorized in terms of the Medicines Act. So, meaning there should be a difference between products that are prescribed for medicinal purposes and those that are used for entertainment. We propose the following. We propose that paragraph A should read, in terms of the Medicines and Related Substances Act, to perform any activity associated with cannabis plant cultivation material, cannabis plant, cannabis or cannabis product. So this is the suggested insertion of paragraph A in clause 1.2. The rest, they remain as they are in the bill.
Chair, I will
I think
take
you will
over
take
this
it from here.
Yes. Thank you, Chair. So, Chair, I think the other issues we just wanted to highlight to the committee, including our role in the master plan, is firstly to highlight the issue that the MRC has raised, which is allowing cannabis for private use is likely to lead to increased use of cannabis by adolescents due to more open use and therefore greater exposure. Adolescents who are regular smokers of cannabis are at risk of what we call arrested psychosocial development, which obviously would lead to other medical consequences. There is also a growing concern regarding the long-term effects of regular cannabis use on the adolescent brain. We need to remember that the human brain development continues until the age of about 25. So this is also a concern, particularly for young people who are in emerging adulthood and their access to cannabis and their consumption of the product. We also know that there are some short-term effects in terms of cognitive functioning and memory based on research that was conducted in Cape Town, which the MRC has been part of.
Sorry, Dr. Pillay. Can
Yes.
Daniel switch off his camera? Proceed, Dr. Pillay.
Thank you, Chair. The bill does address the need to protect children. It defines children as under 18s, but it doesn't specifically refer to adolescents, and someone reading the bill may assume children as meaning a much lower age group. And so we do think that it doesn't go far enough in protecting adolescents from accessing and exposure to cannabis. Among other things, there is a need to specify that anyone giving or selling cannabis to a person under the age of 18 or failing to protect a child or adolescent from accessing cannabis should be charged with committing a Class A offense. We think that this is quite a serious offense, particularly with the impact it would have on adolescents particularly. The other area that we wanted to just highlight is the risk of harm to others. While there is a very real risk of substantial exposure of people who do not use cannabis on the second-hand cannabis smoke basis, it is unlikely that the provisions in the bill are sufficient to prevent this risk from occurring. The bill does take this into account. We acknowledge that to some extent by making it a Class D offense to smoke cannabis in the immediate presence of a non-consenting adult, and to make it a Class C offense to smoke cannabis in the immediate presence of a child. However, it might be helpful to specify a distance, particularly now with COVID as well, whether inside or outside, and these offenses could be increased to Class C and B offenses respectively. The purpose being that the bill is a private use bill, and smoking in the presence of children or adolescents or consenting adults cannot be deemed as being private. On the issue about motor vehicle crashes, we do want to say that cannabis use does affect what we call the perceptual motor functioning, and thus increases the risk of motor vehicle accidents. We note in the bill that you've taken account of this to some extent by amending the National Road Traffic Act of 1996. But we need to pay sufficient attention to resources and training and equipping the police with this kind of equipment so that they can detect drivers that are cannabis impaired so that prosecution can happen. So I think it's one thing to have it in legislation, but it's really important that this is actually effected in some way. So it's not clear what financial resources will be made available, but I think it's important for the committee to be aware of those consequences. And then I want to also share with you the demand on mental health and substance abuse treatment, which is something we are anticipating. So while there is only a small risk of cannabis triggering latent mental health problems among people with underlying risks of these conditions, the numbers are not negligible. Our local research has highlighted the burden of cannabis-induced psychosis on under-resourced psychiatric services in KZN, the Eastern Cape, and the Western Cape. It's also highlighted the role it plays in inducing the first episode psychosis. So any increased use of cannabis is going to increase the need for psychiatric services. And these services are already chronically under-resourced and unlikely to cope with an increased demand. In addition, currently cannabis comprises between 22 to 40% in the case of Eastern Cape, Limpopo, and Mpumalanga for drug treatment demand in South Africa. And in other provinces like the Eastern Cape, 24%, and provinces like the Free State, Northwest, and Northern Cape, 77% of drug pre-treatment demand among persons that are 19 years and younger. And this has been a trend that's been increasing over the past decade, although we haven't seen that in Limpopo and Mpumalanga. The funds needed to be provided to address this increased demand for mental health and drug treatment services for persons will inevitably experience problems with the private use of cannabis, including some chronic users who may become dependent, what we call the dependence syndrome. So we do think there's a need for monitoring of use and harms. We have concerns that the bill may cause a slippery slope, and de facto people would start growing cannabis, trading in it quite freely, use on the streets without any of the prohibitions that the bill intends to have. And so we think it's very important that the public are at least aware of the harms associated with cannabis use, and presenting further public health information on this in an accessible format is very essential, and we certainly would like to do that. So improved population level monitoring of the use and associated harms and the reporting of these harms could increase public awareness of the potential risks associated with using cannabis. Improved monitoring will pinpoint where action needs to be taken to address those potential harms. Some of the indicators that we think we should be collecting once this bill is in place is indicators that are needed in the area of the extent and the pattern of cannabis use amongst adults and adolescents, the cannabis-related road traffic offenses, trauma presentations related to cannabis, cannabis-related demand for psychiatric and mental health services, as well as the cannabis-induced psychosis, which we do see. Chair, I'll shift now to the Cannabis Master Plan and our inputs around that and our role in this process. So the role of the Department of Health in relation to the Cannabis Master Plan was first to remove any direct reference to cannabis in the schedules to the Medicines Act, and SAPRA has done that, to include THC tetrahydrocannabinol as a Schedule 6 substance with specified exclusions, and to separately consider the scheduling status of other cannabinoids, example CBD. And then secondly, the Department of Health through SAPRA has amended Schedule 6, as I mentioned, to read as follows. So the THC, to state that the trans-delta 9 tetrahydrocannabinoid is except in raw plant material and processed products manufactured from such materials intended for industrial purposes and not for human or animal ingestion, containing 0.2% or less of THC. And B, processed products made from cannabis containing 0.001% or less of THC, or when raw plant material is cultivated, possessed, and consumed by an adult in private for personal consumption. The department through SAPRA amended Schedule 4 to read as follows. On the cannabidiol, except in complementary medicines containing no more than 600 milligrams of cannabidiol per sales pack, providing a maximum daily dose of 20 milligrams of cannabidiol and making a general health enhancement, health maintenance, or relief of minor symptoms. That's the low-risk claim, calling it a Schedule 0. Or in B, processed products made for cannabis, raw plant material containing 0.0075% or less of cannabidiol, where only the naturally occurring quantity of cannabinoids found in the source material are contained in the product. So these changes are ultimately aimed at the control of medicines including complementary medicines, medical devices, and scheduled substances as is required by SAPRA, intended for the medical purposes, but continue to seek control over any medicine or substance containing THC or CBD which exceeds the maximum concentration levels that have been prescribed. The implementation of these amendments have had the effect of removing criminalization of the possession and use of cannabis plant by means of legislation regulating medicine and medical devices. So the department's programs in relation to the master plan, in summary, are to develop a policy on protection of adolescents and mental health care users against the effects of cannabis. Secondly, to review the Medicines and Related Substances Act to align it with the objectives of the National Cannabis Master Plan. And thirdly, to review the Foodstuffs, Cosmetics and Disinfectants Act to align it with the objectives of the Cannabis Master Plan and the National Health Objectives as well. Chair, thank you very much. I will stop there.
Thank you very much, Dr. Pillay, and to your team for the presentation. Members, are there any questions, comments? Honorable Niveau Drachens, followed by Honorable Horn, Honorable Swart, in that order. Honorable Niveau Drachen.
Thank you, Chair. Thank you for the presentation. I don't have detailed questions, but in terms of the exposure of cannabis to children, or children getting exposed to cannabis, in the home, say, there's no way of knowing whether children are being exposed to the smoking of cannabis. Children might be in the house, but there's no way of knowing this. So it's just a question of concern. Is there no other way to protect children from the effects of being exposed to cannabis smoke, especially within the homes? I just wanted to know. Thank you, Chair.
Thank you very much. Honorable Horn.
Thank you, Chair. Firstly, allow me to make the comment that I think this was a helpful presentation in the sense that I think it centered heavily on regulation in the light of the fact that Parliament, as it is, has been, I don't want to say ordered, but on the back of a court judgment. Ultimately, we are then to facilitate private use of cannabis. So in that light, I think the presentation was quite helpful. The question I want to ask is towards the latter part of the presentation, where it was envisaged that the scheduling of the use of cannabis and cannabis-related products will unfold. Whether the department has considered the specific framework around private use versus determining that certain products are then to be included